Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, for those of you who've been geeking out on this channel, you know this morning we dropped a video because yes, your United States Supreme Court dropped the bomb today on the gun control agenda. I told you this morning we only had a few minutes to get through parts of the opinion. I've had an opportunity to get through all of it. It was a fun read. So listen, we're going to spend a few minutes today. You guys need to really understand the significance of this case. This goes far beyond just some oppressive gun laws in the state of New York. So today, we're going to spend a few minutes talking about how the Supreme Court drops a bomb on gun control. Okay, so hot off the presses, a New York Pistol and Rifle Association v. Bruen. Now I'm going to pull a few extra nuggets out that I did not have a chance to find this morning and get you acquainted with this case and how significant this could really be. Now let's take a step back and let's kind of refresh our memory about what this case was about. New York, like 5 other states in this country, is what's called a may issue state. That means they may issue you a concealed carry permit if they feel like it. What that really means is you have to show a special need. It's not just like, I'd like to defend myself and my family. No, you actually have to almost demonstrate a likelihood of having to shoot somebody before they will then, of course, consider giving you a firearm. In New York, it's even worse because you actually have to have a license to keep a firearm inside your home. So the main issue to be decided in the New York Pistol and Rifle Association was, does the Second Amendment provide us protection to defend ourselves through the use of a firearm outside of the home? Now, of course, obviously, we all believe it did, because the simple language, the right of the individual to keep and bear arms shall not be infringed, seems like plain English. However, the court seemed to have a hard time with that. Now, obviously, the big news is that New York's concealed carry law, as is for about 5 other states, New Jersey, California, Maryland, and so forth, you're on notice now that your concealed carry laws are probably all unconstitutional and you're probably going to need to revamp them. So that's the main issue, and we're going to talk about that today. But the other thing we got to talk about is, I think, an issue that many people are not focusing enough on. And I think that this is really the important nugget to come out of this. Because as we talked about in this video that we did just yesterday, one of the big things is when we're taking a look at gun control legislation, what is the level of scrutiny that the appellate court is going to look at? The tighter the scrutiny, the more strict the scrutiny it is, the less likely that gun control legislation can actually survive a constitutional challenge. Now, if we begin to loosen that scrutiny up, perhaps like an intermediate scrutiny level, of course, that allows this balancing test, this weighing of options, and it allows politically oriented or motivated judges to put their thumb on the scale one way or the other. That is how we see a lot of these restrictive gun legislation, your AR bans, your magazine bans, all the crazy things that the state of California does, some of the crazy things that the state of Washington does. How do they survive federal challenges? They survive federal challenges because the federal circuit courts, the Ninth Circuit here in Washington State, all the other circuit courts, they apply an intermediate scrutiny and says, well, the societal interest outweighs the individual right, the law is good. And unless the United States Supreme Court accepts review on these matters, well, then that's the law of the land. Now, the most important thing to come from this is a very clear announcement. And this, I cannot overstate this enough, a very clear announcement. And this was made very clear by Justice Scalia in the Heller case 14 years ago, but for whatever reason, the federal appellate courts could not understand very plain English in that opinion. So let it be said again, scream it from the mountains, that when we are talking about restrictive gun control legislation, strict scrutiny is the standard that must be applied. Okay, so like I mentioned, I wanted to talk about 2 things in this opinion. The first one is the actual result here. What happened? Okay, the New York State concealed carry law was struck down as unconstitutional. It violates the Second Amendment. New York is violating it through the 14th Amendment. I think that the court best summed it up when they said, hey, listen, if you guarantee a person a constitutional right only in their home and nowhere else, it basically means the following. To confine the right to bear arms to the home would nullify half of the Second Amendment's operative protections. Okay, now the big issue, and I'll explain to you why this is such a huge issue in just a moment, but the huge issue, and I don't know why more people aren't talking about this, is that we have consistently argued that, listen, anytime we're looking at these restrictive gun measures, like what New York is doing, like what the state of California does, like what the state of Maryland does, like what the state of Washington is trying to do, that we have to apply a strict scrutiny analysis. And this intermediate scrutiny analysis that the lower courts have been getting away with is what's allowing all of these crazy gun control regulations to remain in place. Now, today, in a almost spiking the football fashion, which I had really hoped for in that video that we did yesterday, the court, I think, made it abundantly clear that moving forward, there will be no other level of scrutiny to be applied to Second Amendment legislation other than strict scrutiny. The court specifically stated, today we decline to adopt that two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Now, as we talked about, the difference in strict level of scrutiny is we basically look at the plain text of the constitutional amendment and the prohibited activity, and if it's covered by that language, that's it, we're done, it's unconstitutional. If we're going to get down to the gushier intermediate level of scrutiny, we allow the court to consider things beyond that, and so there is a second step to our constitutional analysis. The court very soundly rejected that two-step process today by stating, despite the popularity of this two-step approach, it is one step too many. Step one of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying a means-end scrutiny in the Second Amendment context. Instead, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. And that is a huge thing that you're going to see throughout this opinion. For those of you who are going to geek out and read this opinion yourself, you're going to see about the historical context, because what the court says, and it's not different than what Justice Scalia said in Heller, is that, listen, when we go back and we look at the historical context of what types of firearm restrictions have been permissible, if we see a history of those types of permissible restrictions, firearms in very sensitive places, automatic weapons, other destructive weapons and things like that. When there's a history of it, the court's willing to entertain those restrictions. But if there is no history of it, say, oh, I don't know, a magazine ban, an assault weapon ban, something to that effect, well, that likely is not going to survive constitutional scrutiny. Do you begin to see the importance of what the court announced today? Now, there's another important reason, and I've articulated this already in this video as well as several other videos, why this intermediate level of scrutiny is not preferred and actually quite dangerous, and it's what we call judicial legislation. And that is that when the legislature cannot get things passed, sometimes a judge can do it for them with very creative interpretations of the law. When we give judges a carte blanche scale and they can balance as however they wish, then politically motivated judges can certainly rule in a certain way by merely interpreting a statute one way or the other. The Supreme Court today was very wise to that, because they specifically, in again stating why strict scrutiny must be applied, pointed out the following shortfall. Moreover, Heller and McDonald expressly rejected the application of any judge-empowering interest-balancing inquiry that asks whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other important governmental interests. And they also pointed out that that decision is probably not best left to justices who typically don't know anything about firearms. So perhaps the most important announcement to come from this case is the following. We reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. And so I really think that it could not be any more clear that what the rule of law is moving forward. And this is what I want everyone to take away from this case. This is the reason for you in the 2A community, you, the lawful and responsible gun owner out there, to celebrate, is that the warning shot has been fired across the bow for all of these gun control states, that AR bans, which have no historical perspective whatsoever, magazine restrictions, which have no historical perspective whatsoever, any of these other crazy licensing laws, some of these other crazy restrictions on where we can conceal or open carry, where there is no historical perspective supporting that, there is no constitutional means by which they can be upheld. Listen, we're going to be doing more videos about this opinion. I'm going to have a chance to digest it more. Of course, more people out here in the YouTuberverse will be weighing in with their opinions on things, and obviously things will evolve. What's going to be really interesting is to see how states like California and New Jersey, are they going to thumb their nose at the Supreme Court, or what are they going to do? Because if you're in the California state legislature, the New Jersey state legislature, the Maryland state legislature tonight, you might want to get back to work tomorrow morning. You have some laws to rewrite. In the meantime, if you guys have any questions about this opinion or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.